Your Honor, the evidence here, even from the Secretary of State, is, for instance, the counties didn't check to see if the witnesses were registered. That's the evidence in the case. There's only 6 or 7 that did, resulting in thousands of ballots presumptively, and this is a common sense presumption, because you've got 180 people kicked out in Little Carver County because the witness isn't registered, and you have none in Minneapolis and none in St. Louis County, you can presume the people in each county are as smart as each other. So all you have to do is extrapolate, and I hesitate to use this case for anything, but they did that in Bush against Gore when they compared the relaxed standard in Broward County with the unrelaxed standard in Palm Beach County and said the population should have equaled. When Plymouth kicks out 75 for signature mismatching and 31 counties in the state kick out none, we've made our case. You can't make it any better than that.
Counsel,
the garden variety differences between counties or the garden variety problems that crop up in every election do not lead to a constitutional or statutory problem. It is only where you have this complete failure, this complete absence of any standards, this complete absence of any effort on the part of the election officials to comply with the law, that this court has held that there is a cognizable injury in a contest. And that squares completely with the holding of the U.S. Supreme Court in Bush versus Gore, where, again, the Supreme Court said it was a standardless recount. It was a standardless recount that took place under the auspices of a court, where a court could have imposed standards and simply turned a blind eye to the standards, so that you had some counties doing partial recounts and some counties doing full recounts and some counties counting ballots one way and some counting ballots another way. There is nothing in the record of this case and nothing in the trial court's findings in this case that would suggest that level of problem.
Counsel, you bring up Bush versus Gore, and you've talked about some long-standing principles that apply in equal protection. Why aren't those long-standing principles about intentional discrimination go by the wayside in light of Bush versus Gore? And is it Bush versus Gore, at least with respect to election law, puts in place a different standard and those long-standing principles don't apply anymore?
I think what Bush versus Gore says is that you can have conduct that becomes so arbitrary, that is so egregious that it essentially rises to the level of intentional. And I think what the court found in Bush, and it's the reason why, though we have not argued, as others have and many in the future will, that Bush versus Gore was a one-and-done case, no precedential value. I think it's fair to read Bush that though it has precedential value, the court was clear in limiting it to a really unique set of circumstances where you have conduct, where you have a court overseeing a recount. And let's remember, in that recount, these ballots in this recount were open. Governor Bush's team knew what the score was, and Vice President Gore's team knew what the score was. The veil of ignorance about what was in these ballots had been lifted at that point, and they were looking at completed ballots. Any standard in that circumstance, with a court standing by and letting these ballots be counted by whatever standard the election officials came up, you had an extreme example of where gamesmanship by the two sides could take place. Because they knew if they ruled that the standard applied in a certain way with a certain ballot, they knew what the outcome would be, because they in fact had the ballot in front of them. It was opened. None of that was present on Election Day in Minnesota. In Minnesota, you had hardworking, and the trial court found this and found it clear, and it was the testimony of every witness. You had hardworking Minnesotans who went and did everything they possibly could to administer a fair election.